Okay, you're very welcome today to our session on GDPR. My name is Emma Ganesh. I'm the CEO and founder of Landed Hiring Software. Today's webinar is effectively covering what you can do over the next 9 days to ensure that you are GDPR ready, set aside some of the worries that you may have, and just bring it into perspective, really in mind with recruitment and how GDPR is going to affect your recruiting processes. Give you a little bit of background if you haven't been on one of our webinars before. I am the founder of Landed, a hiring software company. I've been a recruiter since 2001, so I've certainly done my time. And in that time, I have personally witnessed a massive change and the impact that technology has had on the recruiting processes, from the way companies advertise jobs and right through to screening and hiring people. In 2014, I founded Landed along with my co-founder, and we set up very much with the aim of simplifying the recruitment process from advertising to onboarding, so that our clients could really get to the people that they wanted to hire quicker. And by accident, we've almost become a GDPR sort of spokesperson, because what we do ensures that all companies are compliant and have a very transparent window on their recruiting process. But I won't go into that in too much detail today. I'm just going to focus on GDPR itself and the impact that is having on recruitment. So that's who I am. Today's presentation, just to give you some background as well, was prepared by Michael Green, who's our chartered accountant, and Michael is our certified GDPR practitioner within the business, and he has attended courses and is certified to actually give GDPR guidance and information. So he is an indication that we take this very seriously, and we've done all we can to ensure that not only are we GDPR compliant, but that our clients using the software are GDPR compliant as well. So what we will cover today is very straightforward. We'll cover what is GDPR, how does it differ from the Data Protection Act, the accountability and governance concepts that it brings in, what is consent, privacy notices, what you have to do with those, how cookies are impacted, what would happen if you were found to be in breach of GDPR and the sanctions that are in place, and then a very quick summary and finally what steps you can take at the very end to ensure that you are ticking the right boxes and being compliant by next Friday. So without further ado, let's just get straight into the information. GDPR, or the General Data Protection Regulation, will take effect from the 25th of May, which is next Friday, and it effectively places significant additional responsibilities on data controllers and data processors. And in this instance, Landed is both. We're a data controller of our own information and our own employees and our own clients, but we're also a data processor on behalf of our clients as we hold their candidate information on our systems. GDPR is about personal data. It doesn't cover business data, such things as accounts and P&Ls, etc., but it does constitute anything that is considered personal data. Protection of personal data is fundamental right and is enshrined within EU chartered level. It is about putting back control into the hands of the individual and forcing businesses to put data protection front and centre of their business processes. GDPR applies to processing carried out by organisations operating within the EU and organisations outside the EU that offer goods or services to individuals within the EU. So there's a lot to be covered. It affects all EU citizens, and that is regardless of whether the company is located in the EU or not. Within GDPR, what is new? GDPR areas, the main two areas are accountability and data governance. Controllers and processors are required to implement the regulation and demonstrate that they do so, and demonstrate being the key point here. Businesses must put systems or processes and policies in place to ensure that they can prove compliance. This requires management buy-in, and it must be a top-down approach, and you must ensure that adequate processes to maintain and monitor that compliance. A definition of personal data has remained largely the same with the introduction of GDPR, and it has been expanded to include things such as online identifiers, which could be IP addresses or cookies, and these are now classed as personal data. So if you're using online systems for your recruitment process and you have a cookie tracker, then that is considered personal data, and you must make sure that that is protected and trackable. Sensitive personal data is classed as specialised categories of data, including genetic data, biometric data, or data concerning health, and GDPR requires explicit consent for processing such data. Companies processing large volumes of special category data should appoint a data protection officer. So anybody who is taking a lot of this personal information in, especially within the special categories, must ensure that they have a designated DPO. So if you don't have one within your business now, then it is something that we would strongly recommend that you put in place, or bring in, at the very least, an outside consultancy and have them be your representative. GDPR applies to both automated personal data and to manual filing systems. So if your filing cabinets are full of candidate records and employee personnel files are covered under this regulation, you must put appropriate safeguards in place around your manual filing systems to avoid data breaches. So I think a lot of people over the last few months, when I've been talking to companies, have said it's okay, we're not affected because we do everything by paper, but paper is data. Data therefore needs to be protected. So it's not about going online and doing everything online, but it is about putting in place safeguards. So having a good filing system under lock and key with only limited access to that information. Data subjects have additional rights under GDPR in respect to how their data is handled, specifically the right to port their data and the right to be forgotten. So if, for example, and this is outside of the recruitment prospect, but just to give you an idea, if I decide I'm going to change dentists, I've recently just got some text messages from my dentist, but I decide I want to move dentists. I have the right to ask my dentist to transfer all of my information to my new dentist and delete all of that information from my previous dentist so that they no longer have that information. And I have the right to request that and for it to be done without due delay. In the case of recruitment, if I no longer wish for a company to process my data, I have the right to request full deletion of my applicant record and all associated data. However, there is a caveat to that, and this is subject to any restrictions in respect to governing laws. So if you need to hold on to information for a reasonable length of time, which is quite a grey area in recruitment still, but if you want to ensure that you have all the information that you need, should down the line something be brought to court, then you have that information to hand. So if a candidate does ask you to remove their personal data, if they've been employed by you or there was some form of dispute with their application process, then you have the right to retain that under special circumstances, and you can prove a legitimate right to hold on to that. If, however, it's just a candidate who didn't make the grade, never even got as far as shortlisting, if that person wants their data removed, then it's a reasonable request that you would remove that data and prove that you have done so. Consent will be harder to obtain and harder to rely on, so companies need to put tracking mechanisms in place to ensure that they can both gather consent effectively and maintain it. And I'll go into that in further detail as to how you can manage consent in the next slide. With GDPR, a special emphasis needs to be placed on transparency. Companies need to update privacy statements to be concise, clear and unambiguous, and they should be standardised and auditable. And you should ensure that you keep a log of changes to any privacy statements, put in processes in place and track policies that were in place when an individual provided that data to you. So if an applicant applies to you at a certain point of time, you must be able to tie the privacy policy from that point in time to that application. If subsequently your privacy policy changes, you must either notify that applicant that it has changed and can get their consent that they're happy with it, or accept that any outcomings are related to the privacy statement when they applied for the job. Penalties for breach of GDPR are extremely onerous and have the potential to cripple businesses. Their fines up to 20 million euros or 4% of global turnover can be imposed. The ICO remains the regulatory body in the UK and it is responsible for ensuring GDPR is adhered to. Data transfers to non-EU countries are specifically mentioned in GDPR, and the authorities have issued a whitelist of countries which are deemed to have adequate data protection controls. It is important to note that the USA is not on this list, The new EU-US Privacy Shield replaces Safe Harbor, and you should ensure that any US-based processors are self-certified under that Privacy Shield. So they have slightly different regulations. You may wish to check that out if you're hiring or storing information in the USA. So overall, main things that are new, it's what is classed as personal data has slightly changed, bringing in line your IPs and your cookies. Privacy impact assessments must be conducted so you can be aware of what privacy risks you have. You must therefore then protect by design, put in place a data protection officer and make sure that person is named and can be contacted. There are data breach notifications, and they will happen. I'm convinced that somebody will be made an example of at some point. You have the right as a candidate to be forgotten. You have to ensure that you've given consent to track certain data, and that data is portable to other solutions should the candidate request that. In terms of accountability, Article 5 principally relates to the processing of personal data. So the data controller, i.e. you, the company, shall be responsible for and able to demonstrate compliance with accountability. This means you must be able to prove that you process lawfully, fairly, and in a transparent manner any personal data, that you have collected it for specific, explicit, and legitimate purposes only, and that you're only collecting information that you need to make those hiring decisions and nothing outside of that. That you have adequate, relevant, and limited to what is necessary the information that you're gathering, and that the information you're gathering is accurate and, where necessary, kept up to date. That it is retained for only as long as necessary, and as I said, that is a little bit of a grey area, but you yourselves will have your own policies in place as to how long you store and hold candidate records for. That also then any information you have is processed in an appropriate manner to maintain security. So in terms of that, privacy statements must provide more detailed information and be concise and easy to understand, so that the candidates are fully aware of where their information is being stored. So that is the one first thing I would suggest to all companies that they do, is that if they haven't done so already, that you review your current privacy policy and that you put in place information that it covers the GDPR regulations. If you're looking for what to include in those, I would strongly recommend going to the ICO website, as they have samples and of what's in their privacy policies and what is acceptable to cover you and be compliant. The other main area within GDPR is data governance. So data protection officers, your DPO, it needs to be in place if you're either a public body or core activities consist of processing data that requires regular systematic monitoring of data subjects on a large scale, or you're processing large quantities of special category data, such as we've mentioned earlier, medical information or health declarations, etc. Data protection by design and default should be baked in. So DPDD, data protection by design and default. It should become part and parcel that anything that you do, you are protecting the data that you gather. Data protection impact assessments, DPAIs, basically will indicate for you what risk that you pose and what mitigations you can put in place to actually limit that risk to exposure. Also, with data governance, the DPOs are specifically responsible for retaining and maintaining records within the organisation. So what we would suggest here is that with your DPO, that you devise workable policies and procedures on how to govern data and how that data is processed, and put these processes in place to ensure that records can be maintained accurately. And that can be fairly straightforward done, especially if you have a trained DPO. They're aware of what information you can have and store. In relation to consent, this is covered by Article 4 in the GDPR articles. Basically, in general, you have to have data subjects consent to process their data. And while there are specific circumstances where consent is not strictly necessary, especially within recruitment, these generally revolve around legal requirements such as compliance with another law or to protect data subjects' rights, and also to protect the rights of the data controller. The conditions for consent are outlined here on this slide. Consent must be given freely, specific, be informed and be unambiguous. And by this means that the person giving consent should be very aware, fairly easily from the statement that you put up in your privacy policy, what it is that they're giving consent for you to hold, and how long and what you're holding it for. If you're processing data for multiple purposes, consent should be given for each of them. So companies should consider how they record consent for each purpose. What systems do they have in place to manage opt-in and opt-out across channels and processes? So if you're taking candidates' information and you're looking to use that information perhaps later on for marketing purposes within your organisation, you must make it clear on the application consent area that you are going to use that information for marketing purposes. If it's solely for recruitment purposes only, then that's what you make clear, that that is all that it is for. Individuals should be able to withdraw consent easily, and it should be given as freely and easily as if consent as it was taken. So if consent was given via a tick box on a landing page, then it should be removed via similar means. So updating preferences on landing pages or even via SMS, it should be able to remove via SMS. So specific rules apply around processing of restricted data, and this can be found within Article 9 of the GDPR. And consent should not be considered freely given if a data subject has no genuine or free choice. It is important to note that pre-tick boxes on forms do not constitute consent. So you'll notice that on a lot of websites, it used to be they had almost pre-ticked the forms and you had to untick them to withdraw your consent. Now companies must have these boxes where the candidate actually physically ticks the box, not removes the tick. And this is something that you'll notice across all websites that you're on, and that you have to actually opt in as opposed to opting out. However, in regards to consent, recruitment is slightly different. There are 6 areas that you can prove where consent has been given. The data subject has given consent by a tick box is a common one, but processing data and application forms is necessary for the performance of a contract to which a data subject is party, so an employment contract. So in respect to if they are submitting a job application to you, then and they have signed and submitted at the end of it a candidate declaration, then that is them giving you consent to hold their information. So it doesn't have to be a tick box exercise. You can assume that consent will be given if processing is necessary for compliance with legal obligations to which the controller is subject to. So once again, if they're asking them to give you personal information and it's a legal requirement, then again, you can take it that consent is given to do that. Processing is necessary in order to protect the vital interests of the data subject. Processing is necessary for the performance of a task carried out in the public interest or the exercise of official authority vested in the controller. And then finally, especially in regards to recruitment, processing is necessary for the purposes of the legitimate interest pursued by the controller or by a third party. So in terms of if you were using a system such as Landed, which is used by our client, so you're the controller, you're the client, and you're collecting in that candidate's information, then it can be deemed that consent has been given because it is necessary and it's a legitimate reason for us, Landed, as a third party to hold that data for you, being your data controller or processor. Moving on to privacy notes, a lot of companies are updating these, and as rightly they should do so. So what you need to ensure whenever you're processing privacy notes is you need to know what information is being collected and state on your privacy note why you're collecting that information, who's collecting it if you're using a third party, how it's being collected and stored, why it's being collected, how it will be used, and who, if anybody, it will be shared with. If you're looking for guidance on privacy notes, as I said earlier, I would strongly recommend going to the ICO website where there is a guide to data protection, privacy notices and transparency and control, and it'll give you a full indication of what you can and should include within your new privacy policies. And it must stress here that it's important that your privacy policies and notices be updated on any documents that you send out, including your privacy policies or any terms of contracts. Also, you need to include it on your websites to make sure that your IT teams have updated your privacy notices and that incorporates how you're collecting your information from third parties such as Landed. Cookies are also another area that are covered by GDPR. Sites will need to always be available to have an opt-out. So even after getting valid consent, there must be a route for people to change their mind. Soft opt-in is likely the best consent model, where website owners should give visitors the opportunity to act before cookies are set on the first visit to the site. So it's vital that companies have these cookies if they are using them, and that they get permission before the person moves anywhere else within the site. So you'll find that, for example, on sites such as EasyJet, if you're trying to book a flight and you're about to upload personal information, you will have to opt in to consent to those cookies and that tracking before you can actually upload any information. And we would see this as best practice in regards to recruitment as well. Consent will need to be different, specific to different cookie purposes. So sites that use different types of cookies, and there are different types of cookies, with different processing purposes, will need valid consent mechanisms for each purpose. But what we find, I'm not going to go into too much detail on this, is this is more to do with the marketing and the tracking on your website as opposed to recruitment. And so if it's something that you want to look into, then I would suggest you have a discussion with your IT team and perhaps with your marketing manager as to what cookies you use and for what purposes they're being tracked. And does this impact on your online recruitment process? So what happens if you don't adhere to GDPR? This is an area that a lot of people have asked me about over the last few months. So it is important to note that GDPR is now a regulation, whereas the Data Protection Act was basically guidance, and it was something that was best practice to sign up to. But if you're found to be in breach of GDPR regulations, then or there has something happened within the data and you have found that there's been a data breach in your organisation, you must report it to the ICO within 72 hours. You must outline that you've taken measures to remedy any breaches that have taken place. And if the rights or freedom of individuals are at risk, that they must be informed with undue delay. Sanctions for failure to comply and to be found in breach of GDPR can lead to fines of up to €20 million or 4% of global annual turnover, whichever is greater. And also, if you find that the individual's details has been leaked and has been breached, then the individuals also have the right to claim compensation. So it is important that you get it right and that you have the right protections in place. But we live in a world today where, unfortunately, no technology is completely bulletproof. I think even the larger organisations will attest to that. So what is considered reasonable is that if you discover that there has been a breach on any of your information and you even suspect that there may or may not be, if you suspect there's been a breach, you should report it to the ICO and then buy yourself that time to find out what the breach has been and to put in place any remedies to protect and minimise any risk to individual data. So that's a lot of information to go through. Generally, in regards to what you should do now, there is still time. It may seem like it's fast approaching upon us, and there's a lot of information to do. But most companies we find have put in place a lot of points already. The main things you need to do to ensure that you are GDPR compliant is to really ensure that any personal data collected in the recruitment process is necessary. So first point being would be to take a complete audited review of your recruitment process. If you're still using paper-based application forms, what information are you asking the candidates to fill out on that application form? Is everything that you're asking for absolutely necessary, or can some of that information be asked at a later stage? So in the case of health declarations, does that have to be collected at the very first point of application, or can that be collected later? Do you need to have health declarations on absolutely everybody who's going to be screened and shortlisted, or do you only need the information from people who potentially have the necessary skills? So it's about deciding what information you must prove is necessary. Next step would be to ensure that all hard copy records and files are in order and that the data is secure. So again, if you're still using paper-based applications or have a collection of paper-based applications, that you have these recorded in order, dated and filed and in a secure place under lock and key, and that only certain data protection officers or people who've been designated to look at that information have access to it. Next stage would be to update your privacy notes and cookie policies on your careers website and ensure that third-party data controllers have done the same. So if you are using a third party such as us, make sure that whoever is your third party data controller and data processor, that they have updated their privacy policies and any cookie policies that can be connected back to you. Finally, the most important thing you can do is make sure you educate managers and colleagues within your business. And this in particular comes down to recruitment, in that HR aren't going to be the only people accessing candidate information, which can be deemed as personal data information. It has become sort of pretty much standard that a lot of people will print off CVs or receive CVs via email, etc. What can you do to secure this information? Are you sending CVs out via personal email addresses? This is probably a practice that you should look at and consider a better way of doing something. Is that information secure and held so that only people who need to access it? Have your managers printed off a whole load of application forms and then left CVs lying around on desks? Any information such as this should really be kept under lock and key, and nobody should be able to walk into a room and see somebody's personal information sitting on somebody's desk. So that would be one of the main quick policies that you have, is that you're holding that personal data securely, and the best way to do that, we believe, is to do it in an online and secure way. So which is how Ilambda can help. We basically bring all your recruitment, marketing and applicant tracking activities and all of your candidates' personal data into one centralized dashboard that you can share access with all of the different managers within your organization, so that they can basically view and access the information online. No need to print anything out, and that would constitute personal data, so therefore there's less likelihood to be a breach or for any information to go astray. And so nobody's going to be leaving CVs, etc. in their car or have any of that information accessible. And it's stored on our servers, and our servers are encrypted and backed up. So again, the information is secure from any data breaches. So basically, if you bring all of that together, you can be running your email campaigns, your job board adverts, your social campaigns, tracking your cookies, tracking your source, and importantly, tracking and screening your applicants in one secure area. And you know, and you can prove that the information that you have is secure and safe. Basically, we ensure that you obtain permission from each applicant at every stage. You ask them to give you the information that you only need, and you score and rank that information in an unbiased way, so that all of the information can be seen and shared with the right people. And as you can see here, you can share it with various different managers. We also ensure that your communications are consistent, so that you have templates and standard landing pages, and within this you can put in policies and procedures to keep the candidates informed of what your policies and procedures are. Landed is a fairly straightforward and easy system to get up and running. It starts for £499 a month. You can have that peace of mind that not only are you GDPR compliant, but you're adding value to your employer brand, you're hiring people, not CVs, and that you're overall making better hiring decisions because you're using a solution that is tailored to you. If you wanted to book a free demo to see how that works in relation to GDPR and also other areas, then we'd be happy to get that set up for you. You can email us at info@wearelanded.com, or you can call us on the number listed here below, and we'd be happy to talk you through exactly what it is that we do for our clients at the minute and what we're planning to do for our clients as we continue to grow as an organisation. So hopefully that will give you some insight into what you need to do to be GDPR compliant. And if you've got any questions, I'm happy to stay online and answer them now. If you don't, by all means, drop me a line to emma@wearelanded.com if something comes up later, or follow us on any of our social media channels below, where we put up regular updates. But if there are no questions, I'm going to sign off. Wish you all an enjoyable day. Thank you for joining us. This is going to be available to download from our YouTube website and also from our main library. So feel free to share it with your colleagues and come back to us with any questions.